Hi, this is Tony Williams, Senior Fellow at the Bill of Rights Institute, and we are pleased to bring you another episode of Scholar Talks. For this episode, we are honored to have our scholar, Phillip Muñoz, who is going to discuss the Warren Court. Thank you for joining us, Phillip.
Pleasure to be with you.
Appreciate it. Let me introduce you. Vincent Phillip Muñoz is the Tocqueville Associate Professor of Political Science and concurrent Associate Professor of Law at the University of Notre Dame. He is the founding director of Notre Dame's undergraduate minor in constitutional studies and also directs Notre Dame's Tocqueville program for inquiry into religion and public life. Dr. Muñoz writes and teaches across the fields of constitutional law, American politics, and political philosophy, with a focus on religious liberty and the American founding. His first book, God and the Founders, Madison, Washington, and Jefferson, which I have right here, my signed copy, my treasured signed copy, a First Amendment church-state case reader called Religious Liberty and the American Supreme Court, The Essential Cases and Documents, and the co-editor of American Constitutional Law, the leading constitutional law case book designed for undergraduate instruction. He's the recipient of an NEH grant and currently writing a book on the natural right of religious liberty and the original meaning of the First Amendment's religion clauses. He has published widely in scholarly journals and national periodicals, and is an award-winning professor for teaching, a widely sought lecturer, and has made many scholarly contributions to BRI over the years, which we are grateful for. So again, thank you for joining us.
No, it's really good to be with you.
Great. So let's dive right in. Okay, we're gonna be talking about the Warren Court today, which is relevant to some of our other materials that we're wrapping around this conversation. And so my first question is, can you provide a little bit of historical background that helped shape the Warren Court, which lasted from 1953 to 1969?
Yeah, sure. Again, thanks for having me. I hope this conversation is useful to those teachers and citizens who are watching. I'm a big supporter of the Bill of Rights Institute, and I've always enjoyed participating and teaching in the programs you offered. So, I mean, so the Warren Court, again, 1950s, 1960s. I don't know, maybe different scholars would approach the background differently. I'd actually go back to the early 20th century and the progressive movement. And the Warren Court, I think we start to see the implementation of modern progressivism, but the philosophical ideas of modern progressivism really were introduced into American politics earlier in the 20th century by intellectuals like Herbert Crowley and President Woodrow Wilson, especially political science professor, before he's a politician. Woodrow Wilson was probably one of the first, maybe the first, to talk about the Constitution as a organic or living document, the living Constitution. Wilson contrasted the living Constitution with the founders' understanding of constitutionalism, implicitly the dead Constitution or the Constitution of the past. Today we talk about living constitutionalism versus originalism. What the Warren Court applied that living philosophy, even though Chief Justice Warren was not a constitutional theorist per se, to all sorts of parts of American life. So it was a time of judicial activism, in many cases for results that most of us very much like and would support. But it was an implementation of progressive notions of the role of the court and the role of the court to update our Constitution, to bring it, keep it up with the times, as it were, to lead to social justice. And it really has shaped sort of what the judiciary has become, even to this day, even though there are a number of justices appointed by conservative or Republican presidents. Really, we still live in the shadow of the Warren Court in many senses.
Right, and this whole discussion of a living constitution versus originalism and all that, it's come up during our Supreme Court hearings that we're witnessing right now.
Yeah, we're recording this right as the Barrett hearings have finished. So yes, it's very much a relevant topic. Well, yeah, Justice Brennan, of course, was the great 20th century leading member of the Warren Court, a great 20th century justice who really advocated from the position of the Supreme Court the philosophy of living constitutionalism. So, yeah. Maybe I'll just say one more word about that, just to clarify our terms. You could, I haven't thought this, I haven't used this, but I think this will work. You could say the older understanding of the Constitution was that the Constitution was sort of the rules by which we have agreed to live by, you know, the architectural plan, and justices were to enforce those rules. The notion of a living constitution is more the Constitution is a concept, sort of, you know, an idea for a house. And the role of the court is really to drop the rules to help implement those general concepts of liberty and equality. So instead of understanding the Constitution as, here are the rules that we have adopted as a people to protect religious liberty or free speech or federalism or separation of powers. These are concrete rules, and the Constitution is our governing document. In the progressive or living constitutional school, the Constitution is just a document of vague generalities or general principles, and the rules are then made up by the Supreme Court. And so you can see one has a much more activist or managerial role for judges. And that's what we saw in the Warren Court. Part of the reason the Warren Court, you could say, got away with it or was able to adopt that activist role is because of Brown versus Board of Education, which I'm sure we'll talk about, and how that was seen as a great moral victory and sort of legitimated what the Warren Court was doing.
Right. The court did some other things too. And so in several of these cases, we're going to see an application of the Bill of Rights to the states and local governments as well. And so what is this incorporation doctrine, and how did it, you know, affect some of the reasoning in their cases and even the concept of federalism? Okay,
good. Yeah. So incorporation. The Bill of Rights, background, I mean, I'm sure people watching this video know this, but let me just, a little background information. The Bill of Rights, of course, are amendments to the Constitution. They're not part of the original Constitution. It's part of the deal of ratification that the Anti-Federalists, those who are against the Constitution's ratification, would agree to ratify it with the promise of amendments. It's a complicated and interesting story, but we get a Bill of Rights as amendments to the Constitution, and the Bill of Rights only applies to the national government, the federal government. So the First Amendment, lots of people don't know this or have forgotten this. Originally, the First Amendment only restricted Congress and the national government. It didn't apply to the states. Famous case in the 1830s, Barron versus Baltimore, articulated this, but everyone agreed. It wasn't controversial. After the 14th Amendment is adopted, after the Civil War, 14th Amendment restricts the states. There's a question, to what extent does the 14th Amendment incorporate or apply the Bill of Rights or other fundamental freedoms against the states? And the doctrine of incorporation is the way the court, through a number of different cases that basically spans the 20th century, even into the 21st century, applies various provisions of the Bill of Rights to the states. So in 1919 and 1925, a couple of free speech cases, the court says the First Amendment free speech clause restricts the states. In the 1940s, it was the religion provisions, and the Warren Court did a lot of this. So they nationalized the Bill of Rights, applying it to the states. And the doctrine by which they did it is known as incorporation. That is, the 14th Amendment, specifically the Due Process Clause, incorporates the Bill of Rights and other fundamental freedoms, not necessarily limited to the Bill of Rights, and restricts state governments.
Okay. Right, and you mentioned Brown versus Board of Education in 1954, and that's really one of the first major decisions of the Warren Court, and probably its most famous case. What are the essentials of that decision?
Yeah, Brown involved segregation in public education, right? The Jim Crow South, and there's a precedent on the books from, I think it's 1896, Plessy versus Ferguson, that said separate but equal, or segregation was constitutional. The dissent in Plessy was Justice Harlan, and he said, no, the Constitution is colorblind. So Brown comes in 1954. The court says separate but equal is not equal. The court does not adopt Plessy's colorblind dissent. So the Warren Court does not say the Constitution mandates color blindness, but rather just separate but equal is not equal. So what's the remedy? So it makes segregation in public education, white schools, black schools, that's unconstitutional. But again, what's the remedy? Over time, over a number of cases, the remedy becomes integration. And then part of integration becomes school busing. That happens really in the 60s and 70s beyond the Warren Court. But Brown is commonly understood, properly understood, as constitutionally outlawing segregation. And then the logic of Brown is applied to all public schools, all sorts of other issues, but Brown itself referred to public education.
Right. And the court also issues a few landmark decisions regarding the rights of the accused, such as in Gideon versus Wainwright in 1963 and Miranda versus Arizona in 1966, right? And so everyone who's watched Law and Order knows all about the Miranda rights. So what's decided in those cases, and how do they respect the rights of the accused?
Okay, so Miranda, let me start with the second one, is the Constitution, the Bill of Rights. You have a right to not incriminate yourself. So how is that enforced, right? How do we operationalize the right to not incriminate yourself? And what comes out of the court basically says, look, cops detain you. They have to inform you of your right against self-incrimination. And if they don't, and you say something, but you haven't been informed of your constitutional rights, and that evidence, coerced confessions or even voluntarily given confessions, if your rights have not been, if you've not been informed of your rights, that evidence is suppressed, right? So it's a way to make real or operationalize the Bill of Rights protection against self-incrimination. Gideon involves the right to counsel. So the Constitution, the Sixth Amendment provides you have the right to assistance in a criminal case, right? A right to a lawyer, but you have a right to a funded lawyer, right? And so what we get is the Warren Court saying Sixth Amendment right to a lawyer applies against the states. So if you are in a state criminal case, and the right to a lawyer, the right to counsel is the right to effective counsel or a furnished lawyer. So government must provide a public defender, now we call them, right? As matters of law, these are complicated issues. I think what most people would say, whether or not that was the original meaning, it's a good thing that people who can't afford a lawyer have a lawyer when the state is prosecuting them. These are, again, whether the state should have done that themselves or if that was to be provided under state constitutional guarantees is a interesting question. Lawyers might debate, but from the perspective of civil liberties generally, I think most people think these are good things. We don't want coerced confessions, and we don't want poor people not having lawyers.
Right. So it supports the ideals of justice and supports a limited government from violating the rights of citizens.
Of due process, yeah, sure.
Yep. Exactly. Well, there's also a couple seminal cases in your area of particular expertise on religion in local public schools, such as Engel versus Vitale and Abington School District versus Schempp. And so what's decided in those cases, and how do they, affect things going forward?
Yeah, so the Warren Court is much more controversial on religion and its church-state jurisprudence, especially its Establishment Clause jurisprudence. So the First Amendment says Congress shall make no law respecting an establishment of religion. So Incorporation then applies the no establishment provision to the states. But what's an establishment of religion? Not altogether clear. I mean, I can give you a whole book manuscript trying to answer that question, but the court in 1940 said establishment clause means there's a wall of separation. What is that? That's not clear either. So these cases in the 60s are in the context of public schools, and New York State had something known as the Regent's Prayer. I wrote this down because I knew we were going to talk about this. So I'm just going to read you the Regent's Prayer. This was said in New York public schools prior to 1962 at the beginning of the school day. It's called the Regent's Prayer because the regents, the governing body of the school, wrote the prayer. Let me see here if I can find it. Seems pretty innocuous. Let's see, where is it? I wrote this down here. Okay. Almighty God, we acknowledge our dependence upon thee, and we beg thy blessing upon us, our parents, our teachers, and our country. Amen. So no reference, it's not sectarian. I mean, I suppose it acknowledges a creator God or just an almighty God. I was talking about this case a few years ago. I think this was when I was at Princeton, and I had some members of the audience, senior citizens, are like, "Oh yeah, I remember saying that prayer when we were kids." And whatever happened to that? Well, somebody stopped saying it. So in 1962, I believe, in Engel versus Vitale, the court strikes down the Regent's Prayer because it violates the wall of separation. I mean, it's only about 60 years ago. It's sort of amazing that we had government-sanctioned prayer in public schools. Seems like a long ways away from where we're at now, but that was a common practice, and that is a pretty controversial decision. And then the other case, the Shump case, I think 1963, the court strikes down the practice of Bible reading. This was in Pennsylvania and I think Maryland schools. It varied from locality, but in many schools there was passages of the Bible were just read without comment at the beginning of the school day. Other schools recited the Lord's Prayer, a Christian prayer, though, as I like to say in class, it was written by a Jew. And they struck that you can't start the school day with a prayer. And this is part of the wall of separation that the Warren Court really implements and makes, really brings down from earlier cases, and it kind of dictates the place or the lack of a place for religion in public education.
Right, now, as a follow-up, and something you've written about extensively, because I read it in your books, this was based upon a letter from Thomas Jefferson to the Danbury Baptist Association, and other founders might have had a different view, or other founding documents might have shaped the court differently had they alluded to those. Is that correct?
Oh yeah. So the phrase "the wall of separation." Thomas Jefferson wrote this when he was president to the Danbury Baptist Association in 1801 or 1802. I can't remember. Or the phrase itself dates back to Roger Williams, founder of Rhode Island. But even how Jefferson used the phrase "the wall of separation," not altogether clear what Jefferson meant. And there's some very good scholarship. A gentleman, Daniel Dreisbach, who has made the argument that what Thomas Jefferson was referring to in this wall of separation was the wall was between the national government and religion. That is just about federalism. It wasn't separating religion from politics, but rather the national government from religion, meaning this is a state question. And some of his evidence is when Jefferson was governor of Virginia, he issued presidential prayers, proclamations of days of Thanksgiving, and the like. It was interesting that the court turned to Jefferson, who had nothing to do with the drafting of the First Amendment, to interpret the First Amendment. And the founders' positions on church and state are complicated. I mean, they all believed in the idea of a natural right to religious liberty, that the government can't persecute you for practicing your religion, or can't make you go to this service or that service, or make you to go to any services at all, can't punish you for the practice of your religion or the absence of religion. They all agreed about that. But to the extent that government could help support religion through grants of land or general benefits, there is no publication there is no public education at the time of the founding. Most education is done through churches. So can you help fund the church in order to educate the body politic. The founders disagreed on that. George Washington, Patrick Henry, Alexander Hamilton were more sympathetic to the idea that government ought to nurture morality, and one of the ways you nurture morality is by nurturing religion. So there's a civic purpose, and just like what we talk about public education, we say we need an educated citizenry, so we fund public education. You have to pay your taxes for public education, even if you yourself don't have kids or your kids are not in public education. It's part of the common good. That's what George Washington said about religion. I mean, good citizens need to be moral. They can govern themselves, and religion helps support morality, and therefore it's a legitimate object of public spending. Others, like Madison, agreed with George Washington. They said, yes, religion is necessary to the success of Republican or Democratic government, but government isn't necessary to support religion. Religion doesn't need the support of government. So it's not that they disagreed about morality or the goodness of religion, but just Madison thought religion would be better off if not supported by government. It's kind of a libertarian or classical liberal position on that. The idea that government should be hostile or that government should be free from all religious influence, that's really not present at the founding. That's more of a 20th century doctrine that emerges from the court's jurisprudence, including jurisprudence in the Warren Court.
Right. And one more follow-up, because it's so fascinating and because this is really your area. And so we use these cases to then later on, no prayers at, like commencement services or football games and that kind of thing.
Yeah. So, it's sort of interesting. So I teach in a law school, but I'm not a lawyer by trade. And for many of those who are in the law, legal professionals, the Supreme Court sets the rules, and then you operate within Supreme Court precedent. So Supreme Court has this leading precedent, still a good precedent, Jefferson versus Board of Education, where they say a wall of separation, and that sort of effectively becomes the law. You can make the argument, I think you could easily defend this argument, that Justice Black and Justice Rutledge, sort of the two most important votes in the wall of separation case, they rewrote the First Amendment. But that's the law, and that has its own life now, and all sorts of precedents built up, and we still argue about these things today.
Right, and should do in a republic, right, and in a democracy, right? We should have healthy deliberation about these things, and civil.
We should mention, just about the religion, sort of interesting for all sorts of reasons today. In 1963, in a case called Sherbert versus Werner, this was a free exercise clause case. So the First Amendment says Congress shall make no law respecting an establishment. We've been talking about the Establishment Clause. But also the First Amendment says you can't prohibit the free exercise of religion. And in 1963, the court, in this Sherbert case, Justice Brennan, again, the intellectual force in a way behind the Warren Court, said the free exercise clause mandates exemptions from generally applicable laws that in practice burden religious exercises. So today, exemptions, the idea that the First Amendment or religious freedom requires exemptions, that's criticized by those on the left as being a conservative position. Many conservatives do adopt that position today, but it was actually Justice Brennan who authored that idea. And this was part of the living Constitution, he said. He said, originally the First Amendment protects the idea of religious freedom. At the time of the founding, he didn't really care what they did at the founding, but what does religious freedom mean? How is it effective today in the modern administrative state where government does so much? And he says the only way you can really protect religious freedom is by giving exemptions to religious citizens from generally applicable laws that in practice burden religious exercises. Again, that was the liberal dogma really up until the last few years. So that case is also part of the Warren Court's legacy.
Right. Is there an example of an exemption that the teachers and students might be familiar with from recent times?
Well, the big ones are the Hobby Lobby case. That's done under federal law, the Religious Freedom Restoration Act, which implements the Sherbert ideal. So that has been the big one that's been conscientious exemption from military service. There's actually also some Warren Court decisions on that, exempting both religious pacifists, but non-religious pacifism as well. If you have a moral objection to fighting a war, the Warren Court issued some decisions. These are not constitutional decisions, but statutory decisions extending exemptions. The Warren Court in general, I mean, it's not just religious minorities. The Warren Court was friendly or activist in protecting all sorts of minorities, but including religious minorities. That was sort of liberal constitutionalism of the Warren Court. There's been a real shift in terms of protecting religious liberty on the left. I think at least left legal academics.
Switching gears here, maybe a little bit, and maybe into even more controversial. What was decided in Griswold versus Connecticut decision? And how does that right to privacy that's enunciated in there help to shape the decision in Roe versus Wade that was decided a little bit after?
Yeah. So I mean, it's in constitutional law. Sometimes these cases that you would think are not very important, or minor cases, can have a very big role. So Griswold versus Connecticut involved a Connecticut statute that prohibited birth control. It was on the books. The case itself was sort of manufactured. No one was arrested for procuring birth control, but it's a long story on how the case gets to the Supreme Court. But it does get to the Supreme Court, and the court strikes down the state prohibition banning birth control as applied to married couples because there's a right to privacy, the court says. So this is really the birth of the idea of the right to privacy. Privacy is not mentioned in the Constitution, at least in the context we think about it in terms of sexual morality. There's a Fourth Amendment prohibits unreasonable searches and seizures. That's certainly a type of privacy. But the court says in Griswold, there's a right of marital privacy, actually. Privacy is in the marriage bond, or the marriage bedroom, they actually say, and the government can't intrude into decisions that married couples makes. And so the court founds this right to privacy. That's later expanded because the Equal Protection Clause to mean you have a constitutional right to contraception. All individuals do. And then, of course, the right to privacy. The court cites Griswold in Roe versus Wade. So obviously, perhaps the most controversial and consequential decision in the last 100 years. The precedent on privacy is laid in Griswold.
Okay. Very good. And so as we come to the end of our discussion, what are some maybe general reflections on the Warren Court, particularly as it may have helped to reshape the principle of federalism, or really anything else you want to talk about?
Yeah, well, I could talk for a long time.
Sure.
I mean, we haven't talked about the federalism decisions per se. Maybe let me answer that question in a way that most people might not, but something I've just been thinking about a lot. The Warren Court had all sorts of decisions on pornography. This is the time when Justice Potter Stewart says, I don't know how to define pornography, but I know it. I know it when I see it. Right. So the Warren Court really struggles to figure. So the First Amendment protects free speech. It's pornography speech. They say, well, obscenity is not protected by the First Amendment, but what's obscene and what's not? And the court really can't figure out a workable rule. And because the standards are relatively vague, what happens is you just get a loosening of the laws against pornography, right? Now, pornography in this 1960s is nothing like it is today, right? This is pre-VCR. Certainly pre-internet. I mean, it would be interesting to think if you could ask these justices back in the 60s, like, this is what this is going to produce in 50 years. The general point is the court in the 60s made it much more difficult for local communities to limit pornography or obscenity. The court contributes greatly to a loosening of laws. Maybe that's good, maybe that's bad. But it really strips local communities of the ability to use the law to set the moral tone, especially in matters of sexual morality. Well, fast forward with the VCR and then with the internet, and we just have complete, deregulation, non-regulation of these matters. So these decisions in the 60s related to pornography really have had these monumental, consequential impacts for local communities and their ability to what I call to regulate the moral ecology of the local community. Now, maybe technology would have outstripped local communities in general, but just imagine if so I have 3 little kids, so I think about this stuff all the time. If all pornography had been filtered into a different domain ending, right? I mean, I'm terrified that my kids will just accidentally, be on the computer. And that's all part of the legacy of the war on court. I think maybe one of the worst parts of its legacy, personally. Of course, they didn't foresee what was going to happen, but they did certainly make it harder for local communities to govern themselves, in these matters at least.
Philip, I want to thank you for joining us today. Really appreciate it.
Thanks for having me.
Thanks for all you do for BRI.
Okay, thank you.
And thank you to all the viewers who joined us. And you can check out our Life, Liberty, and the Pursuit of Happiness textbook at billofrightsinstitute.org. Thank you.